Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru Tumarkin, LLP. We are an employment and disability law firm practicing in Canada, throughout Ontario, British Columbia, and Alberta, where we have offices. We also represent clients throughout Canada, other than in Quebec and the territories. Welcome to discuss disability matters. We welcome your feedback. We welcome questions through various social media platforms. You can get answers to questions live if you go to, with your disability questions, disabilityrights.ca. I'll start off with a topic that is being raised quite a lot these days, and that is with respect to CPP disability benefits. We field questions from leads, I suppose, people in the public interested in wanting to know, how does CPP disability benefits affect, or how do CPP disability benefits affect entitlement under a long-term disability policy? And why should people apply for CPP disability benefits? So I'll start off by saying this. When you have an LTD policy, that is long-term disability, through your employer, the policy very likely will require or provide that if you are entitled to CPP disability benefits, such benefits form an offset from what the insurance company has to pay you. Who pays CPP disability benefits? That is a benefit that is paid by the federal government. You apply to Service Canada. The criteria for CPP disability entitlement is you must have an illness or a condition that is, number one, severe, number two, prolonged, and number three, to the extent that you cannot work in any gainful occupation. Many people think it's the most difficult thing to apply for. To some degree, to some extent, it may be difficult, because in order to prove that it is severe, you have to prove that, and the doctors obviously will assist with this, your family doctor or your treating physician. Why is it severe? Why is it preventing you from working? Then you have to show that it is prolonged. Generally, they look at it as, has it been going on for a year? Are there other treatments available? If so, they may want you to exhaust those treatments to see if there is some recovery. And then they look at whether you can work in a gainful occupation, which may not be what you were doing before. If you were earning $100,000 a year, obviously that's gainful. If you're able to earn $30,000 a year, is that still gainful? So that's a whole different discussion. But from an insurance perspective, when you have a disability policy, there are generally two definitions for total disability. The first one is you have to prove that you cannot perform the duties of your own occupation. Then that changes. That own occupation phase is generally 2 years. Then it changes to that of any occupation. You have to prove that you cannot perform the duties of any other occupation based on your transferable skill sets, which would allow you to perform duties in any setting, be it for yourself in a self-employment capacity, for a different employer, or from home. It's at that juncture where insurance companies normally push people to apply for CPP disability benefits, because the CPP disability benefit is an offset, which means the insurance company gets to deduct it from your LTD benefit. I'll carry on with that in a second. I see we've got a question, and the question comes from Brad Valley. Are you entitled to long-term disability benefits if you cannot do your own occupation, but your employer is providing modified duties? For example, a welder being given office work. It depends on where you are in the policy. If it is in the own occupation phase, the employer may say to you, well, and remember, there's an employment section to this as well, to discuss modified duties in an accommodated fashion. But purely looking at it from a disability perspective and a disability policy perspective, you should be entitled to benefits if you cannot perform the duties of your own occupation. If it is that you are required to work in a different occupation after 2 years and you can work in another occupation, benefits may end. But if all of this is happening during the own occupation phase, the common law may have a duty for you to recover and to work or retrain in a different occupation if you cannot do the duties of a welder, in your example. And now you have to do office work, or office work at least is being offered to you. Insurance companies, if that were to happen, it depends on what that income would be. It depends on what it would pay you. It depends on what your capacity would be if you're able to do that. There may be a return to work provision program in the policy, rehab provisions for short, which mean that the insurance company may top it up. But strictly speaking, if it is an own occupation policy for the first 2 years, that should be the focus. Can you perform the duties of your own occupation? But I can see, and I have seen cases where the insurance companies, especially the lawyers, will argue that you have to mitigate, which means it's the legal term, which means that you have to take steps to reduce the exposure at the other end. In other words, you have to take steps to retrain, or you have to take steps to get back to work, even in an accommodative fashion. If they were to deny you based on that, please reach out to us, because we do speak to people on a daily basis with respect to disability-related questions. We can look at the exact circumstances. So look at the policy itself, look at the denial letter, and look at what your circumstances are. Why is it that you're being pushed into something which you're not qualified for potentially? Or at what stage is it? Has it been that you've been able to receive benefits for 1.5 years, and now they're starting to push you into a different role, which to prepare you for the change of definition phase? We've got a question from Gina. I've been on LTD for 4 years. I'm looking to sell my home to lower my expenses. Will this have an impact on my LTD payments? What should I expect if I do sell? Each policy, disability policy, will have offsets. Remember when I started speaking about CPP disability offsets? That would refer to offsets under the policy. There may be other offsets as well, which may be if you were receiving WCB benefits, or if you were receiving a severance potential. It all depends on the language of the policy. It's related to employment income. If you were to sell your house, and you've been on LTD now for 4 years, that is not an offset under the policy. The proceeds of the sale should not be an offset under the policy, because it's not employment income. It's not something related to your activities that you're receiving income for. It's the same with rental income. If you have somebody living in your basement suite and you're receiving rental income from that, that's passive income. It's not employment income, and it should not be deemed an offset under the policy. So if you were to sell your house, the insurance company should not be in a position to try and reduce your LTD benefit by the proceeds. If they did that, by all means, reach out to us. If you sold your house and you moved out of the province, or you moved away to a different country, there may be issues there. So we would want to have a look at what the policy provides for, because some policies may say that you cannot leave the province or even the country, rather the country, for a certain period of time, or beyond a certain period of time, without the insurance company's consent. My argument would be that their consent would have to be reasonable. I've seen cases where people have left the country to go get other forms of treatment, or to go visit family on the recommendation of their doctors, where the insurance company then denied the claim, saying that you did not advise us, or you did not request us for our permission, or where they even denied permission. And in my mind, it should be reasonable. Having said that, it depends on the language of the policy. If there's a denial, as I said, please reach out to us and we can discuss it further with you. Okay, you're welcome, Brad. Then we've got a question from Ziggy. On LTD, working a few hours a week as an Uber driver to keep me social, can I still apply for CPP disability? Good question. So CPP disability benefits, as I said, one of the criteria would be you have to be unable to work in a gainful occupation. So if you're working as an Uber driver and you're making a certain amount of money, generally I think you're allowed to earn just under $6,000 a year and still receive CPP disability benefits. I think it was $5,500 last time I looked. It may have gone up now. But the focus is you have to show that you cannot work in any gainful occupation. So it depends on how much money you're making from your Uber driving. If it is to keep you social, if we're speaking about CPP disability, the Service Canada will be looking at what is your capacity. If you're earning, I don't know how many hours you would be working, but if you're earning, say, $1,000 a month, that could very likely disentitle you from CPP disability benefits. Question from Tom. I am coming up to my changes in definition date, and my insurer wants to review my return to work options or see if I am suited for a different position. I'm scheduled to have at least one more surgery, and my doctor has said I'm still a way off from returning to work. Should I have this meeting with my insurer to discuss return to work options? Many policies will require that you have to cooperate with the insurance company. So if you refuse to have a meeting with the insurance company, you are exposing yourself to a potential denial of the claim, because they may say you are breaching your obligations under the policy. Having a discussion with the insurance company, I think you probably should do that, depending on the language of the policy. Does that mean, though, that you have to participate in a return to work program? If this is just a meeting to discuss those options, you can have the meeting and then tell them that you are in a position not to return to work at this time. If you are scheduled for another surgery, it depends, I suppose, on what type of surgery it is and how long it will continue to have an impact on your capacity to work. But when it gets to the change of definition, this is a crucial juncture in any disability policy, in any disability claim. The insurance company is going to look at, do you have transferable skills? And do you continue to have medical restrictions, limitations, obviously, but do you have transferable skills that will allow you to work in another occupation? And that means not just for your own employer, for any employer in any setting, even if it is on a part-time basis. So going back to Brad's earlier question, if it had been done at the change of definition, say the insurance company says to you, well, we accept that you work as a welder, but now we think that you can go work as an office worker, even when you were being able to work from home with reduced hours, as long as it pays you roughly the same as your LTD benefit amount, then the insurance company will likely deny your claim. Of course, it's not as simple as that. So if your doctor supports that you continue to be unable to work, have your doctor involved in this process, because as I said, this is a very crucial time. It is important that you see your doctor on a very regular basis during this specific time. Under the terms of the policy, you see your doctor regularly in any event, but when it gets to the change of definition and there's discussion or talk about a return to work and your doctor is not supportive, see your doctor regularly so your doctor is in a position to advocate for you, I suppose, as to why it is that you cannot return to work at this time and why it is that you remain disabled within the meaning of the policy. The doctor can put that in writing. So if the insurance company is proposing a graduated return to work, one would expect that they would submit that to your doctor and have your doctor sign off. If your doctor disagrees, have your doctor put it in writing, send it to the insurance company. And if they still insist that you return to work, one obviously would think that you would follow your doctor's advice. If they deny your claim, as I say to every question, reach out to us, because we will offer you a free consultation to discuss with you what your options are so you can be in an informed position to decide how to proceed. Go to disabilityrights.ca, as you can see on the screen, submit your questions and we can respond to you. Okay, that was the same question. We have a question from Ashley Burrows. My sister's insurance company is asking her for all sorts of statements because she sometimes sells a few dozen cookies for friends and family. Will they cut her off because of this? This is a gray area. So it really depends on what her activity is, what her activity level is. If your sister is, selling a bunch of cookies and she's making income from that, the insurance company may say to her that our policy provides that if you are working for any wage or remuneration other than in an approved rehabilitation program, then your benefits will terminate. So will they cut her off? It depends. It depends on the level of activity. It depends on the level of income. It also goes to function, right? A disability claim is not just about the diagnosis. The most important thing in a disability claim is functional impairment. So we look at what are the restrictions and limitations. If somebody has depression and the doctor says they cannot work because of depression, the claim is going to be denied. You have to explain what the restrictions and limitations are. Why is the person functionally impaired from performing their duties? They have lack of focus, lack of concentration, cannot multitask, cannot comprehend new information. They have low motivation, low energy, extreme fatigue, oversleep, undersleep, social withdrawal, cannot interact with people, etc. And then you put that into correlation with respect to what the person's occupational duties are to decide or to at least underline why it is that they cannot work. In a situation where your sister may be selling cookies, it depends again on how much she's doing, but they're also going to be looking at the fact that she's able to do that. So in your situation, or at least in your sister's situation, I think it's a very good idea to have a discussion with one of our lawyers who will review the situation and then maybe give you their impression of where things are at. And if there is a denial, of course, hopefully we can assist. We've got a question from Sheena. My insurer just sent me a letter saying my payments will be cut off because I didn't inform them about recent travel. I went to visit my family for a few days, but they live in the same province just a few hours away. Can they do this? Is there anything I can do? Remember what I said earlier. It depends on the wording of the policy. If your sister went to visit her family in the same province, the insurance company cannot use the fact of the travel as a contractual basis to deny the claim. In other words, if the policy says that you cannot travel outside of the country, you cannot travel outside of the country without our consent, or if you did, then your claim would be terminated. This may more likely be something where they may be looking at the fact of the travel and thinking about if she's able to travel, they may be thinking that the functional impairment is not such that she is totally disabled. But if they did cut you off because of this, I've had cases and seen many cases where a doctor may recommend to somebody with significant depression to go visit family, where they're in a familiar environment, where they have the support of their family as a form of treatment. And the insurance company, and that was when the person went to visit somebody outside of province or outside of the country, and the insurance company denied it on that basis as well. I disagree with that denial, and we were able to assist that person. So, that's not an isolated incident. So, if the insurance company denied the claim based on that, it doesn't say in this email or this question that she was traveling by plane or by car. I've seen cases as well where a person did travel by car because it says that she's a few hours and the family is a few hours away. That they may say, for example, if you say you have a sore back, you cannot sit or stand for long periods of time, yet they will use the fact that the person is able to travel in a car for a number of hours as a basis to say that we find that your restrictions and limitations as you report them are not credible. Therefore, we're going to deny your claim. So it's really fact specific, and I would want to know more about this before I can respond in a more detailed manner. Then, how much money would she have to make? This is again from Ashley. How much money would she have had to make from selling cookies for it to be a problem? It really depends. I would suggest that your sister reaches out to us so we can have that discussion with her. If she is baking a few cookies and has been recommended by the doctor, for example, to do something which gives her purpose, if it is mental health disorder, and she's selling some cookies, making a few $100s here and there, it shouldn't be such a big issue. But it really depends on the exact circumstances. So I would want to know exactly what is happening before we can give a definitive response. We've got a question from Bakir. Bakir. I attempted to return to work while on LTD because my partner suffered a serious injury and we needed the money. After 6 months, my condition worsened as a result, and I attempted. Sorry, I don't have the rest of the question. Oh, here it is. After 6 months, my condition worsened as a result, and I attempted to go back on LTD. But my insurer is now saying I have insufficient medical evidence. I don't understand this. It's the same condition I was already covered for. What should I do? You should contact us so we can look at your circumstances. Why were you denied? How much? I think you said after 6 months. Did you work during the 6 months on a full-time basis? Was it a partial return to work? Did you go back to your own position, or were you accommodated at work? Did you go off work within the first 6 months, or was it after 6 months? He says after 6 months, but it really depends on when there was full-time work. Many policies do provide that there is a recurrence period. In other words, if you do return to work on a more full-time basis and you go off work as a result of the same disability within 6 months, then that would be deemed to be a recurrence. The fact that you tried to go back to work and the fact that you failed, one would think would support your position that you are unable to work. Because many times insurance companies deny a claim saying that the person is not disabled when they haven't attempted to return to work. If you actually do attempt to return to work and you saw your doctor on a regular basis, continuing to report to your doctor how the return to work is affecting your condition, if it's getting worse, etc. One would think that would be supportive evidence that you do remain disabled from working. In other words, disabled to the meaning of the policy, and the insurance company should reinstate your benefits. So for you, Bakir, I would want to know more. Was it before or after 6 months? What was the extent, like I've said before? But there definitely will be an arguable claim. In my mind, we'll just discuss your options with you if you do contact us. And on the screen, you can see, you go to disabilityrights.ca for more information. Also have a question from Denise. Can I request copies of the reports from the insurance company's doctor? This is a question that comes up regularly. And I've seen many situations where the insurance company will say, no, we don't have to release it. I disagree. There have been cases where the insurance company would say, we cannot release it to you, but we can release it to your doctor. So you can file a freedom of information request. If you do want a copy of your entire insurance file, insurance companies would want you to sit with your request in writing. And if they refuse to give the, if they refuse to give the report to you, insist that they give the report to your treating physician so that you can go to your physician, if it's your family doctor, and discuss the report. I would genuinely recommend that in any event, that if you do get denied, or if they have sent you for an independent medical examination, and they have the report and they say, our doctor that we sent you to says that you're not being properly treated or recommends that you do go for this treatment, I would recommend that you get a copy of that report sent to your doctor and go have a discussion with your doctor, because often when insurance companies say those things, it is after that doctor has now reviewed your doctor's notes and your current treatment regime, and where they may have made some recommendations. So I would think it makes sense to have your doctor then weigh in, whether the doctor agrees with the position, whether the doctor agrees with new treatment medications or regimes being implemented. It is crucial for you and your doctor to be in an informed position so that when they respond, they have a basis to respond to. In other words, they understand what the insurance company's doctor's position is, and the doctor who has been seeing you, following you, recommending treatments for you, will be in a position to rebut what their doctor say if they do disagree. Ziggy says, my insurance company wants to send me to a cognitive assessment. They say it's not the insurance doctor. I'm still waiting for a phone call from the center. Any advice or caveats? My insurance company wants to send me for a cognitive assessment. They say it's not the insurance doctor. Okay, so what that means is the insurance company, when they say it's not their doctor, they're suggesting, or they want to send you for what is called an independent medical examination. In this situation, yours, it is a cognitive assessment. Probably will be done by a neuropsychologist, one would think. And if it is a cognitive assessment, what I'm taking from this is there may be some form of cognitive impairment that you have been basing the disability claim on. So there may be anxiety or depression leading to lack of focus, concentration, etc. So what's going to happen here is they're going to have you assessed by as they would term it, an independent person or an independent specialist to assess your cognitive functioning, to assess whether there are any deficits with respect to your thinking, your concentration, your focus, your memory, etc. And then once they have that report, if the report finds that there aren't findings supporting that impairment, the claim may be denied. Or if there are findings supporting it, I'm not sure if any treatment recommendation would be made. So if that is the case, I'm thinking, insurance companies do have the right to send you for assessments. Have a discussion with your doctor about this as well. Put in full effort, because you also test for malingering. And if they were to find that the cognitive impairment is not as they say it should be in terms of supporting an LTD claim with respect to total disability, again, have your doctor involved and reach out to us if the claim were to be denied. Insurance companies are allowed to do assessments based on the wording in their policy. If they keep doing it, obviously it has to be done on a reasonable basis. And discuss this with your doctor before you go to the assessment. And once the assessment is done, make sure that they send a copy of that report to your doctor. Question from Henry. I recently applied for CPPD because my insurer told me to do this. My application was not accepted, and now I've received a letter that my benefits will be ending in December. Is this because I didn't qualify for CPD? I still can't return to work. Is there anything I can do? Okay. So first things first. If you've received a denial from CPPD, in other words, for your CPP disability benefits, appeal that decision. I believe you've got 90 days to do so. If the insurance company is now denying your claim as well, I have seen cases where people have had their CPP disability approved and then the insurance company still denies the claim. Is your claim being denied because of the CPP disability denial? Maybe, but insurance companies, as I just said, they may deny the claim for any reason. You still cannot return to work. Is there anything you can do? So your claim for benefits is being ended, which means that the insurance company is taking the position that they're not going to pay you anymore because you're no longer disabled. First things first, as I say to everyone, contact us and we can discuss your options with you, because you will have options. If it is that you cannot return to work and you're still disabled within the meaning of the policy, just because the insurance company says, no, we disagree, that doesn't end the analysis. That doesn't end this. There are options for you, right? You can fight this with our help, or you can take other steps. We will, as I said before, consider the denial letter, your circumstances, look at your claim, look at the policy, and advise you of your options. Yes, there are things you can do. Also, go have a discussion with your doctor. Make sure that the doctor maybe writes a letter for you to advise why the doctor disagrees that the insurance company and Service Canada would say you're not disabled. Because if you cannot work, clearly you are. Question from Henry. I recently applied for, I'm sorry, that's the same one. CPP disability benefits. Remember, if it is denied, your application is denied, you do have an option to appeal. And when you appeal, you can submit further evidence, take the denial letter to your doctor, have your doctor review it, and maybe have your doctor write a letter to explain why it is that you are still remain disabled. They often look at, are there other treatments available? They think that you can work. They're not just looking at your own occupation, right? They're looking at any occupation. So when you do apply, and if it is denied, have your doctor address this. But maybe there are no further treatments available. Maybe your condition has plateaued. Explain why it is that you cannot work in any setting. Focus on the functional restrictions and limitations, be they mental health related, psychological, or if they are physical, or a combination of both. The focus has to be, why is it that you cannot work? And describe your bad day as well, right? So that they understand what it is that would prevent you from working in any occupation, in any setting, for any employer. That brings us to an end for today's session. Thank you for all the questions. Our next session will be, and just give me a second, it will be a employment law Q&A, and that would be at 1 p.m. Eastern Standard Time with Lior Samfiru, my partner, and you can approach him with all your questions related to employment matters. Thank you again for joining, and I look forward to seeing you at our next session. Have a good day.